make a start, and welcome everybody who's tuned in today. Welcome to the Dispute Settlement Centre's webinar on how mediation changed due to COVID-19. My name's David Leonard. I'm the moderator for this afternoon's discussion, and I always start these webinars by acknowledging the fact that I'm sitting here on Aboriginal land, so I pay my respects to the traditional custodians on the land on which I'm seated, which is the Wadawurrung people of the Kulin Nations. And I acknowledge any Aboriginal people out there listening in today and pay my respects to their elders past, present and emerging. And I think we have a really interesting webinar for you this afternoon. This is the second of our series of webinars the Dispute Settlement Centre has been running, and this one is for Law Week, which is an information festival about how the law affects your life. So if you have a look at their website, it's about where you find answers to legal questions and where you get to meet people who help resolve the disputes in our lives. And today you're very lucky because we actually have 4 of them here today, and I'll ask them to introduce themselves, and I'll start with my colleague Helen Skinner.
Hi, so I'm Helen and I work for Dispute Settlement Centre. I'm a regional manager for the Gippsland region, and Dispute Settlement Centre is a kind of wide-ranging, mediates a whole wide range of disputes, but often they involve neighbourhood disputes or disputes in incorporated associations.
Great, thank you, Helen. And Rebecca McKelvey.
Hi everyone, I'm Rebecca McKelvey, the Senior Mediation Officer for the Victorian Small Business Commission. So we resolve disputes of a commercial nature. So those are disputes that are submitted under various different legislations, including the Retail Leasing Act, Small Business Commissioner Act, and also farm debt mediations. And since last year, the Commercial Tenancy Relief Scheme.
Right. And now I'd like to introduce Kelly Charlton. Hi, Kelly.
Hello. Thanks, David. Hello, everyone. My name's Kelly Charlton. I work for the Dispute Settlement Centre of Victoria. I'm the Program Manager for the Fast Track Mediation and Hearing Program, which is a partnership that came from the Access to Justice Review. So we partner with VCAT and mediate matters on the civil claims, goods and services list. So mediation happens on the same day as a hearing. If it resolves, people don't need to stay for the hearing. And lots of interesting cases. So we're a statewide program. So Helen, my colleague, her dispute assessment officers run the program in partnership with us regionally across and other managers across the state. We mediate matters from $500 up to $10,000.
Great, thank you, Kelly. And Daniel.
So I'm Dan Grinstein. I am a lead officer under Dispute Services, currently stationed at the Dispute Settlement Centre of Victoria, working on special projects. I'm traditionally from the Domestic Building Dispute Resolution Victoria, which ultimately hears disputes between homeowners and builders, ranging over a variety of issues. And it's effectively the first stop in getting parties to attempt to resolve the dispute prior to involving the courts, being the Victorian Civil and Administrative Tribunal.
Great, thanks, Dan. And my name's David Leonard. I'm the Community Engagement Officer for the Dispute Settlement Centre, and I've been there for over 20 years. So the number of services that provide mediation and dispute services has grown exponentially since I started in the 1990s. So what we aim today is through a process of conversations, talk about what is this thing called mediation, and which is generally, it's known as a face-to-face kind of activity, and how have we managed to adapt since COVID-19 has made face-to-face communication very difficult these days. So we will be recording, and we have the Q&A function on, so please use that if you have a question as you go along. And also we have the chat, but it will be monitoring the Q&A for questions. So I might start by asking, before we had these complications with COVID-19, how was mediation conducted? What did mediation look like? And I might start with you, Rebecca, if that's okay, about how did the Victorian Small Business Commission run its mediations, and when would it run mediations?
Yeah. Thanks for that, David. So with the Small Business Commission, there was really sort of three aspects to our dispute resolution service. So the first of it was really around our enquiries line and the website. So we provide a lot of information about rights and responsibilities, information about legislation, and we have an inquiries centre, call centre as well. So that was really part of it in terms of being able to empower people to be able to resolve their own disputes and know their own rights and responsibilities. If there is a dispute, they would submit that application to us, and that dispute would be allocated to one of our dispute resolution officers. And through a process of communicating with both parties through emails and telephones, they would try to resolve that dispute through what we call preliminary assistance.
Right.
If that didn't resolve the dispute, then it would move through into a formal mediation process. We would hold those mediations in our offices in 121 Exhibition Street, where we had 3 rooms available for mediations, but also in rural Victoria as well. If we did have parties who were interstate or overseas, we would then provide video conferencing for them as well. So we would hold those mediations, and they would either be half a day or a full day mediation.
All right, and that would be a meeting with a person from your panel?
Yeah, so we had 2 panels. So we have a metropolitan panel and a regional panel of mediators, and they are appointed to a particular mediation. They will come in, run the mediation, and then provide the documents, and then they would leave again. So yes, they were independent contractors. They're not members of staff.
Helen, you had a similar thing when you had, say, mediations between neighbours. Could you maybe, for people who haven't been involved in a mediation process, maybe explain what happens when people get into the room for a mediation, what's generally meant to happen?
Well, I think the first thing to say is that Dispute Settlement Centre in neighbourhood mediations has always had a model of a face-to-face kind of setup. And we do that because we believe that that is the best, or have believed that that is the best mechanism to resolve disputes where there's going to be an ongoing relationship between people. So traditionally we view telephone mediations as something more suitable for transactional kind of disputes, and face-to-face mediation as much more appropriate for longer-term relationships and more complex emotional issues. So yeah, we would always meet face-to-face. We have a number of venues both in the city and regionally, and we traditionally have a 2-mediator model for those mediations.
Right. And Kelly, when you started up the program in VCAT, it was a slightly different context, because the kind of matters that Helen's talking about were often where people would volunteer because they would need to improve their communication, and they would make a conscious choice to come and meet together face to face. But with VCAT, it was slightly different, I understand.
Yeah, so I mean, they're almost compelled to participate to the point of receiving a mediation and hearing notice. So parties are given a minimum of 28 days notice of the date and time. And obviously, once the file's referred to us, the Dispute Settlement Centre sort of built in or reframed the previous mediation program that was run by VCAT by embedding an intake and assessment step. So basically, when the file's referred to us, the dispute resolution practitioner attempts engagement with both parties. Right. We do have a significant number of people that choose not to openly engage with us at that front point. We then list the matter regardless of whether we've engaged with them or not, because the matter does actually need to ultimately be heard by a VCAT member and a decision made regardless. But we find certainly once that hearing notice is issued, that's where they'll dig out the email or pick up the phone and give us a call and engage with us. We can talk to them about the mediation process and also give them some information, some process information about what the day looks like and how they may prepare. So certainly...
Sorry to interrupt. So a lot of people they'd be unrepresented Would
Yeah.
that be right? They don't have any experience with the legal system.
That's exactly right, David. So a high majority of people that attend the civil claims list, certainly within the monetary threshold that we manage, are self-represented litigants. So that, you know, the everyday person needing to pull together the likes of evidence and sign declarations of service and serve evidence. So that sort of terminology they need broken down into what that may look like. So that's
They might have a very different expectation of what's going to happen at the hearing.
Yeah.
And then they're asked to engage in a negotiation process before the hearing.
Yeah. So the intake and assessment stage really does help parties prepare well for both the mediation, and if the mediation isn't successful, certainly prepares them or puts them in good stead to present their case to a VCAT member.
Right. So they may well be in a position where, having now devoted some time into thinking how they're going to present their case, there is an opportunity to negotiate with the assistance of a mediator at the court, literally at the court doorstep.
Yeah, that's exactly right. So the mediation happens prior to the hearing. So it's a same day service, for want of a better term. So we're not sort of expecting people to, we're effectively using their time, I suppose. The thing that certainly we've moved into is doing what's known as an assisted settlement, where we'll facilitate the mediation sort of through our intake and assessment process. And if we've got both parties in agreement that they want the matter resolved, we've been able to assist settlement prior to it even being listed. So keeping those matters right, out of VCAT as well. So the burden's taken off the court and tribunal setting.
So it sounds like all of you are saying that, mediation is not the goal. It's just part of the end process to try and reach an agreement. And there are multiple opportunities for negotiation leading up to the mediation. Dan, I'll bring you in now because we invited you for two reasons, because your involvement with the domestic building dispute resolution service, but also the residential tenancy rent relief disputes. What's your take on how mediation processes are conducted for domestic building matters?
So the conciliations that we run in DVDRV, so Domestic Building Dispute Resolution Victoria, are probably a little bit more formal than a lot of the community mediations done by DSCV. The parties traditionally do a lot of work in the lead up to the conciliation in terms of getting a better understanding of what it is that they're discussing. And in a sense, they have what they call a list of matters in dispute, which is not necessarily an agreed list, but a list that each party individually lists each grievance or issue that they're disputing, and then has an opportunity to state their position on that matter, and then the other party has an opportunity to respond on a formal document used by the service, and then that's provided to both parties. And effectively, the conciliation itself, based off a lot of the mediation principles, is there to sort of open the session, discuss some of what you might refer to as your big ticket items, so some parts of this are more important than others. And then to effectively work through that list, but through a structured conciliation session. If they're able to resolve that, fantastic, they walk away with an agreement. If they're unable to resolve that, then it's often referred to the Chief Dispute Resolution Officer for consideration for an administrative order to then settle the dispute between the parties. If that's something that's not able to be done, then it's typically progressed with a certificate to the Victorian Civil and Administrative Tribunal, where the parties then have to continue their dispute.
Right. So you've touched on a couple of interesting points there. One is about the formality of the proceedings, because, and each of you to maybe make a comment here about the idea of mediation being a way of maybe avoiding the formality of a legal hearing, which can be quite technical in its rules of evidence and quite daunting.
I think it's more formal in the sense that it's quite structured, because they have the list of matters in dispute, typically with, say, Dispute Settlement Centre of Victoria and a lot of their community stuff. It's more about sort of a specific issue, say over communication, over a particular issue, that then expands from there. Whereas the conciliations at DVDRV can be about the relationships and the communication between the parties, but it's more formal in the sense that it can be a little bit less personal because it's really, you know, about particular issues that need rectification. It can be a lot more personal. So I think formal, it's not formal like a court, but just formal in terms of its structure. Yeah.
Okay, well, I might take that point back to Helen then. You talk about there seems to be there's different aspects when you have people who come in with a mediation. There is an issue of a breakdown relationship, but there also might be some substantive things that need to be sorted out.
Yeah, of course. So we rarely rarely run a mediation just over relationships. There's always usually a substantive issue that, if otherwise not resolved, would have to go towards a legal kind of framework. So it's formal in that sense. It's serious in that sense that all parties know that, you know, they need to cooperate with each other and work with the mediator to try to mitigate the chances of that kind of formal action. But in general, we try to keep the discussion as informal as possible, and as, you know, and mark it as a very different experience to the experience of going to court.
Yeah. Rebecca, with the Victorian Small Business Commission kind of mediations, what's the balance you're trying to get there in terms of discussion, settlement, versus having a sort of a more formal process?
I would say that most probably similar to the types of mediations that Daniel's been discussing. You know, our mediations are of a more formal nature. So our mediations are conducted under particular legislative frameworks. So we will have disputes that are being conducted, say, under the Retail Leasing Act. So there is that formal framework in which they are being utilised and they are being conducted under. So I think that lends a little bit more formality to our mediations compared to perhaps the neighbourhood and community mediations.
Okay, so then what changed? When the provisions came around social distancing, when COVID became a challenge for us last year around about March, what did we need to do to change our processes? And I might start with you, Kelly, because obviously there was a double whammy there because the courts couldn't conduct their hearings and we would have had limitations in running the mediations as we used to.
Yeah, I felt as if we were probably a little bit more prepared for the transition. So I remember the date, you know, as if it was yesterday. And we basically went home, and the following morning we remained conducting our mediations. Certainly our partners in VCAT needed to work on some additional processes because their hearings had predominantly all been face-to-face, and certainly in the civil claims list, the ones that they manage, you know, that we work in partnership with, had all been done face-to-face. So whilst we had matters listed, we were able to continue mediating those, and they were done by telephone. Then, you know, there was this buzz around Zoom and getting that face-to-face, because I think the biggest thing that the practitioners were, or the mediators were missing, was the ability to read the parties. So to look for those non-verbal cues through facial expressions, or, you know, folding of the arms or something like that. So we have, we moved fairly quickly as well to offer mediations via Zoom. And we found by both doing the telephone and the Zoom that we have seen an increase in participation by through the mediation process. So yeah, it's
interesting, because I'd imagine some of those matters would be quite emotive, even if the amount of money in dispute is not enormous by other legal standards. You know, the investment that people have in the dispute, the point that they felt aggrieved enough to take the matter to VCAT, must impact how they behave themselves in these meetings.
Yeah, look, and certainly, David, I mean, I know that I always talk to the team about, you know, $500 has a different meaning to me as it does to the next person. So we can never diminish our, we don't ever diminish our process or our practice because of the claim value. We give each application its best shot. We found through COVID, though, that, certainly something that can happen in mediation. So I think the fast track mediation sits somewhere between our community and the DBDRV Small Business Commission, where we've got that informal process of mediation, where the mediator is facilitating the discussion with an ultimate empowerment to the parties to try and resolve. But at the back end, if they don't resolve, they've got a hearing under an act, and that happens shortly after. So there's lots happening for people in an emotional sense.
And they have to make a decision quickly.
Yeah. So it's about the balance. So our mediations run for between an hour to an hour and a half. So that intake and assessment was, is critical. The one thing that we did, though, to support our parties, particularly through COVID, was we implemented an additional step, which was a pre-mediation call, which happens about anywhere between 2 to 5 days before the mediation, where we'll check back in with parties, just consolidate their position, because the intake is deemed to be the commencement of the mediation process. So the staff that I have, so my mediators, case manage from end to end. So the mediation's already started to happen through that intake. So the pre-mediation is just about consolidating people's positions, their starting point, preparing them for how they may want to engage with the party. And then basically when we call them to commence the mediation, it's sort of that, though the opening statements are a lot shorter, because everyone's aware of why we're here, and allows them just to get into the dispute content itself.
Right. So Dan, and I might also bring Rebecca into this as well. I think also, so as well as having to change out the way we case manage things, the COVID also created almost like a new breed of dispute with rent relief disputes. Maybe Dan, could you talk a little bit about how those were maybe a bit different from the other kinds of disputes that you'd been dealing with, and what made them suitable for mediation or a conciliation process?
So the rent relief grants, are typically, I suppose, less time intensive than a lot of the DBDRV ones, just because it's a very straightforward set of issues, and they're very much close.
Sorry to interrupt. This for residential matters you were dealing with?
Yeah. Yep. So the residential tenancy dispute services conciliations were probably more so like what Kelly's process has been described, and it was very much modelled in some ways off of that process as well. In terms of those types of disputes, they obviously became about because as COVID sort of set in, a lot of industries closed, and because a lot of industries closed, a lot of people just didn't have jobs anymore. And not everyone was eligible for JobSeeker or JobKeeper. So in terms of those disputes, the government obviously created a pathway for them to be conciliated by dispute services. And in effect, they were sort of very short matters in that it was always about rent relief for the most part, with some little communication issues here and there, maybe a bit of repairs on the side. But ultimately what made them suitable is the fact that there was just, there was opportunity for conciliation. Both parties had something to win or to lose. And it was absolutely within their best interests, given, what was happening in the world, to come to an agreement so that they could come out with something rather than come out with nothing. And I think that ultimately we had a lot of good-natured landlords and tenants who are willing to give a little, and to take a little where appropriate, and to come to their own agreement. And where they weren't able to, again, the Chief Dispute Resolution Officer had an administrative process whereby it was assessed for an order. So, relatively straightforward, not too informal, and a largely successful program, because I think just the community is generally good-natured. And like I said, like any successful mediation process, there needs to be a little give and take from both sides, and there was opportunity to do so in that space.
Yeah. Beck, how is it in the small business space with people also seeking rent relief in terms of commercial?
So from sort of 29th of March, when the Victorian government, they introduced the commercial tenancy relief scheme, there was obviously issues around tenants and landlords being able to negotiate the level of rent, so what would be waived, what would be deferred over that sort of eligible period. So obviously there were lots of landlords and tenants who are able to discuss that, they're able to reach their own agreement, but there was clearly a lot of landlords and tenants that really struggled to reach those agreements. And it was really vital for, you know, businesses to perhaps be able to continue throughout the pandemic, that there were these agreements about rental payments. So it was a scheme that really was required for those particular landlords and tenants. They were able to either negotiate some agreements through our dispute resolution officers, but if not, then they were moved fairly quickly, and we did try to have a much shorter process, so they were moved into mediation quite quickly, and our mediators would hold a normal sort of 3.5-hour mediation with them and to resolve that. So it's been a successful sort of process with a lot of success rate. Yeah.
Was that wasn't face to face? Would that be by phone or?
By and large, we moved all of our mediations into video conferencing. What we were able to do was ask our mediators to utilise the platforms and systems that they were familiar with and they were comfortable using. So very rapidly we were able to move mediations, you know, either those mediations that had already been scheduled. So at the very beginning of the pandemic, when we had to move into, we had to all move out of the offices, we were then in a situation where we really did have to move quickly to be able to still have those scheduled mediations operating and being up and running. And we were very fortunate that we had mediators who were able to assist and help and use those platforms that they were used to using.
Yeah. So Helen, I might bring it back to you, because you've had to use a variety of methods, particularly with the neighbourhood matters. We had to, with those ones where we're often it's complicated relationships. What impact did the technology have? What changes did it make to the way people communicated, if they were on Zoom or they were on phone?
Well, I think overall it had surprisingly positive impact on the mediations. First of all, there was great demand for an online service. So we had some experience of telephone mediation through the residential tenancy service, but more and more, and I think, you know, clients generally throughout the COVID thing got used to talking to their grandchildren and friends and relations on Zoom. And so they were actually demanding a Zoom platform. There were some advantages. I think that for a lot of people who would have been reluctant to kind of come to a face-to-face meeting with, and it's obviously difficult when you're in a dispute with someone to come and sit in a room with them, there was a sense of safety about mediating from their own home. And I certainly noticed that we were able to get a lot more perhaps through to mediation than we might otherwise because of that factor. I think that the actual technology worked really well to support people, and being able to see body language face to face for our type of mediation was really critical, for the mediator to be able to observe that and intervene when necessary according to what they saw. Yeah,
I'd imagine, because we were talking before about the formality and informality level of mediation services, and after a while, I think people got acclimatized to using Team and Zoom conferences. And I remember in one mediation that I was doing, it was a dispute about two neighbours who needed to put up a dividing fence because of their dogs. And during the process, you know, a dog kept on barking in the background, and the dogs would bark in the session. And later we realised it wasn't actually their dogs; it was one of our mediators' dogs. So it's, I think there was a slightly changed environment in how people interacted. Would anyone like to comment on that, like from their experience, what happened?
Yeah, I think it's interesting with this notion of informality and formality in terms of our mediations when they're being run via video. And I think there is a little bit of a danger with saying, yes, these are more informal, because you do have, you know, and we've had sort of feedback about, you know, obviously, you know, people doing other things while they're supposed to be sort of participating in their mediation, or people perhaps being distracted and not setting up a proper sort of 3.5 hours in which they're not going to be distracted by either staff members or family. So I think there is a bit of a danger with sort of suggesting that these mediations can be less formal than before. I tend to think that perhaps with online mediations, they are just less intimidating for people. So it's more a case that for some of ours, and you know, whilst we are running commercial mediations largely, there are, you know, lots of mediations that do have, you know, they are very emotional. You know, these are people's livelihoods, or alternatively, they do have a fractious relationship with the other party. So this less intimidating feature of video conferencing has actually been really useful, I think, for certain people, because they like the fact that they can still see the other person, but they're not sitting in the same room. So it's less intimidating. And it's interesting that people have sort of said that's a removal of emotions, which obviously in some cases is a good thing. But then other people have sort of said, well, actually, you know, it's a bit artificial and it's a bit impersonal. So, you know, that's just some of the feedback that we've received.
Yeah. One of the things I think is, as I mentioned before, is people seem to be acclimatized to staff and work meetings, which are often conducted differently online. So often for a staff meeting, you know, a lot of people will be muted because they don't want outside noises to distract. So out of politeness, people tend to hold back in their communication. In fact, in mediation, we want to encourage people. So Helen or Dan, do you want to talk a little bit about what are some of the things that we instruct people when they come to a mediation, what to expect?
Yeah, sure. So we noticed fairly early on that people were using that mute function or turning off their camera. Always left the mediator wondering what was going on. Sometimes we could actually see them discussing something with their support, which would never happen in a face-to-face environment, and was really distracting to the mediation. So we quickly intervened to set the ground rules and to remind people not to do any of those things, because it does disrupt communication unless you do.
All right.
Yeah.
Yeah, Dan?
So yeah, with the face-to-face communications, it was sort of rather simpler because parties already had a pre-existing relationship. They knew what they were there to do. We only did telephone conciliations after COVID. So in the RTDRS space, and DVRB didn't start a lot of the Zoom stuff till later on. So ultimately it was just, there wasn't too many issues in the RTDRS space past any sort of behavioural or personal issues the parties might have had with each other. It was pretty straightforward. And I think for that program, phone was the best choice. I wouldn't have, phones are something that everybody in that space has, computer screens not, especially for tenants under financial pressure, and landlords too.
And I imagine like the chat function too, there's often some technology that could be distracting when you've got a Zoom conference.
Yeah, so I know, David, that we sort of control some of the security settings as the mediator starts the session. So we do disable a number of things. So we certainly don't allow the chat function where, you know, particularly you can select who you're chatting with. So there might be chat going on between the parties that the mediator isn't aware of, or vice versa. We do create breakout rooms. So we do create in the Zoom, we create breakout rooms to conduct our private sessions with. But also if a party does require to ring, say, a business partner and confirm some terms of settlement, or if there's legal representation. So there are a very small few matters that might have a legal rep or even a support person available. So we use the breakout room to sort of move them into so they can have that private discussion. We found also that we get better participation, certainly where there are interpreters required. So it became really difficult over a phone with people talking over the top of one another, and you've just, you know, you've got an interpreter there to interpret the dialogue happening in the mediation, and we just found that switching those initially to Zoom, it worked like a dream.
Yeah, yeah. And I think the technology, it sounds like the platforms available are a lot. The software behind that and the network capability has increased over the last 12 months. That when this first started, a lot of people had difficulty logging in, and the network seemed to be a lot faster now.
I think so. And the other thing that we also provide is the Dialin details. So say, for instance, we've selected a mediation that's going to be a Zoom mediation, rather than someone getting anxious that they don't have a PC or they don't have a mobile phone with a camera on it, that the Dialin details are provided that still lets them into the Zoom community, but they just sit there as a they don't sit there with they can't see anything, but they can still actively participate.
Right. Now, I should ask our audience, by the way, if you have any questions for us, because we've sort of covered a lot of the main points we wanted to talk about. Please drop us a question in the Q&A or the chat. So otherwise, I might ask the last point that I wanted to ask our different panelists is, well, what can you expect now? If you had a matter that you think needed mediation, and I might start with you, Beck. If you've got a small Victorian Small Business Commission kind of matter, what can you expect once you start the process?
Yeah, so at the moment, we are still dealing with the commercial tenancy relief scheme, even though that finished on the 28th of March. We still have a number of disputes that we're still dealing with, and we're still dealing with, we're still holding all of our mediations online. So we are not yet able to bring them back into face-to-face mediations at this point. So very much at the moment, we are still running those mediations and running it online, but really now starting to move towards, well, what happens in the future? So what will we be running and how will we be running these services? And I think that's most probably something that most sort of dispute resolution services are now considering is, well, how do we move forward in the future? And I think with our sort of feedback that we've received, it's a really mixed kind of response to online. So with our client satisfaction survey, which people complete at various different stages of our process, we have been asking, particularly for those that participated in the mediation, to say how they would like to participate in future if they did have a future mediation. And we found that about 58% have indicated that they have a preference for video and online, but 20% would like to resume face-to-face. And another 20% are sort of undecided or they're neutral. So I think this really points to us offering different options, but obviously needing to sort of figure out how that would work, whether you can you can offer people different options, and would that just be based on the preference of the parties, or would we actually be looking at other features of those disputes that might lend themselves more to having a video conference? For example, when you look at the sort of advantage that the video conferencing has in terms of being less intimidating, maybe those where there is a bit of hostility or there's some difficulties in the relationship between the parties, perhaps we could then move them to online and suggest that they attend via video conferencing. Right.
So Helen, is it a similar thing maybe in the future? There'll be a blend. At the moment we can't go to face, so we will have those processes. And if we have matters, say, where which we sometimes have matters where people have personal safety intervention orders, there might be applications on foot, or there might be an order that still allows communication between the parties. How might that help?
Look, I very much agree with Rebecca. I think there's a number of factors there that we would need to consider, one being the preference of the parties, but also the nature of the case. And I can't see that online mediation will go away anytime soon, but I still believe that there's a place for face-to-face as well. In particular cases, and I look back and think of the mediations I've done over the years, I've done mediations between cousins that ended in hugs and others that have ended in handshakes and backslapping or whatever. And I think that to remove that kind of physical kind of possibility of connection at the end of a mediation would be a shame in some ways. So I think, yeah, I think it will always depend on the nature of the dispute and the preferences.
Okay. Still no more questions from the audience, which is fine. Dan, where do you see mediation shaping up particularly in the domestic building?
In terms of the building disputes themselves, look, I think there is a push to bring things back to in-person conciliation sessions eventually. We are starting our on-site assessments later on in the month, which means our builders will be back out on site talking to a lot of the parties. But I think that like a lot of the other spaces, that they're in a position where they're sort of getting good results via telephone. And although you do lose that face-to-face element in helping parties resolve their issues, in saying that you're able to be a bit more efficient in the way that you get matters on, the way you get to party disputes, it means shorter waiting times, quicker resolution for matters that don't need it. So I think that inevitably it will find itself in a hybrid model where some of your more long, the 8-hour sessions or multi-day sessions, which they do sometimes do at DVDRV, are probably better off in person because everyone there in the room. But like a lot of the other services for your smaller, your more basic disputes, telephone mediations and conciliations really are the way forward. It offers flexibility to the community, it's cheap, and it's really accessible to all. Yep.
And I might leave the last comment then for Kelly about, I guess, the lessons that we've learned in terms of all this providers of mediation, but in the public service space where we're part of a bigger ecosystem. What do you think are some of the positives we've gained from this experience?
Look, I think we've shown that the service is still needed, regardless of what is happening outside in the broader landscape of the world. Being there and being available to support people in dispute is something that sort of certainly has been paramount through this process. I think the use of technology, supporting people to use technology. So, we were talking about some anecdotes just the other day, and, I remember taking a call from a person who was going into mediation the following day, but just couldn't quite work out how the Zoom and the telephone and everything worked, and just sitting there becoming an IT expert, I suppose, to a degree. But look, I think the landscape certainly has changed, and I don't disagree with my fellow panelists in saying that, whilst we've sat here and identified, yes, all interpreter matters are now, done via Zoom. I certainly appreciate, both Rebecca and Helen talking about people's intimidation or their lack of willingness to be in the same room. I think providing that safe haven, we run a significant number of shuttle mediations where parties don't even want to see one another. So, certainly creating the breakout rooms and keeping them in there, we can shuttle between them. So we've really diversified and still been able to provide the service through this. And I just think, it was for a lot of our parties, it was one thing that they could tick off the list that they'd achieved through this sort of the last 12 months. For a lot of people, it meant that, yes, they were going to get some well-needed funds if we were able to resolve the dispute. And I think for the future, I believe it will be a bit of a hybrid model. Certainly we need to work with our partners in VCAT. They have not yet returned. I think actually it was this week or next week they have returned to some face-to-face hearings, and certainly some of the different lists may get priority. But I think for our program, we've demonstrated that we don't necessarily need the face-to-face, being the type of dispute that it is, very contractual almost. Yeah.
And often the things you think we could never change, suddenly when necessity requires it, we can. Now, there's a question in the Q&A, so we can use that as our concluding remark, because somebody asked, how do we get into mediation, what pathways did you take to get there? So I'll start by explaining. Yeah, I did study psychology and law at university, and mediation always seems to be a good blend of the two. But I actually was a volunteer in a family reunification program for foster kids, and that's the spark that got me into mediation, because personally, I'm not a person who likes conflict, which is funny because that's our business, our stock and trade. But in fact, you might find a lot of people get into mediation is because they like that sense of resolution, that way of finding a win-win outcome for people. Motivates you to come to work every day and get involved in this kind of line of work. I don't know if any of the other panelists want to add something to that.
So sorry, Dan.
No, you go.
You sure? Yeah, so I've got a legal background, so similar to David. So I had a legal background, trained as a barrister in the UK, and did a short stint for a while of freelance advocacy in county courts, so dealing with a lot of mortgage repossessions and small business sort of disputes. So really saw the sort of court process, but never really felt that it was that satisfactory for a lot of people. So felt that there was a better way, and certainly I'm a great advocate of alternative dispute resolution and see the huge benefits in terms of mediation. And going back to a comment that Helen made about, you know, people shaking hands and giving people hugs, that happens with our commercial sort of mediations as well. And it's really what, you know, motivates a lot of our mediators, because they're really pleased that even within these commercial disputes, there's quite often some family issues, or there might be a partnership, or there might just be some relationships that are broken down. And it's really good that mediation seem to be able to straddle that sort of relationship and also the substantive issue and dispute. And I think, you know, ADR is really invaluable for people. It's quick, it can be really efficient, and it can get sort of small businesses, in our case, really back and running their businesses rather than sort of going through long legal proceedings.
Okay. Dan, you were going to add something to that?
Yeah, so I've got a slightly different background. I've got a criminal justice and a social working background, and I sort of started off my employment at youth justice in more of a restorative justice model, working with young offenders. And then after that, I spent some time at the Magistrates Court, sort of just general registry duties, and also pre-hearing conferences for civil matters and intervention orders and things like that. And it turns out I was better at that than being a registrar. So shortly after spending a bit of time there, I decided to join the DSCV, who was a liaison-based organisation at the time. And yeah, never looked back. And then here I am. And it's more, I mean, it's good to help people resolving their disputes, but I think it's really a necessary community tool as a government. You know, the state and federal move to more of a model of people helping themselves. Dispute resolution is sort of becoming more of a useful but a necessary tool to sort of progress in life. I mean, it's not really just about helping people resolve their dispute. It's a sort of a bit like the old, you know, teach someone to fish and, you know, they can feed themselves kind of thing. And if they can resolve, learn a few lessons from resolving their disputes with us, then they can sort of take that away, and which means sort of there's a less need for government and sort of court-based intervention in the future.
Okay.
Yeah, I think my experience, sorry, just quickly, is that we all come from a huge range of backgrounds. I studied psychology, have had very little contact with the law. And I would say that's one of the wonderful things about working in this sector, is that, you know, people do come from all different backgrounds and bring that together, and bring that knowledge together to assist and benefit like the general community. And it's one of the reasons I enjoy working alongside people who are legally trained and other people like Dan who aren't. So I wouldn't say that if you've got great people skills and a real interest, if not you like conflict, you don't mind conflict as long as it doesn't involve you, I think it's a great career to get into.
Okay. Now, there was one final question that came through on chat, and it's probably a big question. We only have time for a small answer, so Kelly, I might direct it to you, which is along the lines of what kind of investment is required to improve online mediation to make it more effective?
Yeah, look, I think there are lots of sort of online platforms out there. You know, I know we sort of worked, you know, have worked a little with an organisation, Modron, both with DSCV and with VCAT. I think if you're talking that sort of investment, that's, I see that being for more, and, you know, I stand corrected, but for more complex cases where there's lots of sharing of documents and, you know, that technology, that real stable technology that allows you to upload documents prior to the mediation, allows you to share a screen, conduct a whiteboard. Now, some of those capacities are available in Zoom right now. So we're looking at moving sort of our terms of settlement onto a shared screen and sort of looking at getting it typed up so people can see it live. I believe I think that there was something that VCAT were doing around digital signing of documents, which I don't know whether Zoom has that capacity. I haven't sort of looked at that technology, but maybe that investment in respect to looking at a real stable online platform. Certainly Zoom has a lot more securities than it did way back sort of about 18 months ago. But yeah, that's, I mean, and that will require, you know, budget bids and government sort of investment. Those programs are quite expensive to sort of buy, to purchase and keep operating functionally.
I think it's a general dilemma the government has. Often the technology is out there, but you've got to build your systems, and there are, you know, things like privacy considerations and other things. So government's always a bit risk averse and wants to make sure that the technology is going to do the job before they uptake it entirely. So I think that there will be an appetite to investigate that further in the future, but we're not quite sure how much and how long that will take. Well, I'd like to thank our panelists very much for giving up your time and discussing this topic today. I hope that our audience have enjoyed this session, and we will be putting the recording on our website for anybody who missed it. So thank you, everybody.